Greetings, everyone. I am Ali Zia Jaffery, a research associate at the Center for Security Strategy and Policy Research. I welcome you to another session of the Straffasia FES joint workshop that has been organized to enable students and young professionals to learn from and in domains with a view to letting them understand the nuances of international law and the use of force. And I'm fortunate to be joined by Air Commodore Khalid Banuri, whom I have benefited from for the past so many years. His work, his insights, and his inspiration for me. Thank you, sir. Let me introduce the speaker. So, Air Commodore Khalid Banuri Saab will speak for like 30 to 40 minutes. Then we'll open it up for a Q&A. And the Q&A would be on a one-by-one basis. So you'll ask a question, and he'll answer, and then we'll take it forward from there. So Air Commodore Khalid Banuri has a very rich profile, so I'll try to condense that here in the interest of time. Air Commodore Khalid Banuri is a former fighter pilot, a graduate of the UK's Joint Services Command and Staff College, and was the first Director General of the Arms Control and Disarmament Agency at the Strategic Plans Division, as well as one of its longest serving officials. He holds diverse interest and experience of over 40 years in public service, with two of those decades focused on arms control, diplomacy, and multi and bilateral staff level negotiations. Air Commodore Banuri has taught at public sector universities, published on diverse topics, experimented with public-private partnerships, trained young persons in Pakistani perspectives in various governmental and non-governmental forums at home and abroad. He is decorated for policy analysis and continues to provide advice on training rejuvenation and has taught use of force and international law at Qaeda-e-Azam University, Islamabad since 2017. Thank you so much, sir, for joining us. It is ongoing in Europe between Russia and Ukraine, and the prince has been where does international law stand and what does it say? So with that being the hook, I would like you to talk about this very aspect and this important linkage between the use of force and international law, and where, given the very many changes taking place in global politics, how do you see international law taking its due role and taking shape? Thank you
very much, Ali, for a very generous introduction, and thank you, Stratford, for actually thinking of a subject which, a matter of fact, topic, but has significance. Many years ago, after having dealt with some issues of understanding the policy and analyzing it, I felt that there was a need to formally look into international law, because you may understand international law looks at those issues. You can then understand the nuances as well as the limitations of the situation that blends with. Let me just begin by saying that there are lots of thoughts about, is United Nations really needed? Is it adequate, etc.? All these questions need to be contextualized, and a simple discussion on the notion of use of force in the context of direction. In this contemporary environment and the situation issue of from that process thereafter, you could divide this this notion into two areas of why, when, and how kind of a situation in which there's a notion of international law called jus ad bellum, which basically means why go to war? What is the necessity? If a state has to decide for getting into a conflict, what are the things that it needs to do? So it brought out this notion of, is this conflict necessary? And when it went into this decision, it also wanted to see the notion of another principle called proportionality. So these principles actually tended to govern how international humanitarian law started to look at some of those areas. The other of, once states got into conflicts, was a notion of jus in bello. When a conflict actually happens, how to conduct that, and so putting limitations. We remember that in the olden days, this notion of chivalry existed, but it also depended on whether it would be stretched or used or not. This notion actually brought out some principles, turned into legal expectations initially. So with this background, if you look at the UN Charter, and I want to now come to the specific focus of the notion of use of force. What is it that, and I'm not a lawyer, so I don't want to get into a huge jargon or showing you tons of slides of what the law says. So I want you to just focus on 2 or 3 articles that come out from the UN Charter, which directly deal with this. Let me first say, when the UN Charter was evolved, there are 4 aspects which are known as the purposes of international law, of the UN Charter. Basic purpose, maintaining international peace and security, and that was through collective means. And then developing friendly relations among states, and increasing international cooperation, and UN being the center of harmonization of those actions. So these are the purposes. In this backdrop, the use of force was mentioned in an Article 2 of the UN Charter and sub-Article 4. So it's usually referred as Article 2.4, which basically said that in exercising of international relations, the states should refrain from threat or actual use of force in 2 contexts: territorial integrity, against the territorial integrity of a state, or the political independence of a state, of any state. What does it tell you? It gives you the notion of, okay, territorial integrity, the sanctity of that, political independence of a state, but of states. So it is about state-to-state relations. And hence, when you start to think of the contemporary world and think of the non-state actor, then there's kind of a gap that is perceived. We'll talk about this in a bit. And also, so territorial integrity and political independence, or if there's any inconsistency with the purposes of the UN, which I just narrated for maintaining international peace and security, developing friendly relations, international cooperation enhancement, and keeping UN as the center of harmonization of this action. So these are those areas that brought in this notion of that you will not threat the use of force or not, you will not use force. You will notice that in an earlier literature, there used to be references of war. Now, by bringing this up, the reference that you have about whatever happens among states in this context is referred as use of force and is referred as conflict. No state says that that it is going to go to war, because when you do, then you are you can be termed as conducting an act of aggression, which is illegal in this context of international law. So there's a whole chapter of called the Chapter 6 in the UN Charter, which actually says that states must make all efforts of using peaceful means to resolve conflicts. But if that fails, Chapter 7, which has several articles, is about the use of force itself. How this is the part of the jus and bello side of how this can be conducted. And it also determines how to deal with any of those actions. So basically a few articles that start to bring in those ideas of how you deal with international law and when there are issues in which states have these conflicts that cannot be resolved. So actions in case of three areas: threats to peace, breaches of peace, or acts of aggression. So the role of UN Security Council starts to become very, very significant. There are several articles, but let me just refer to two of them, Article 41 and 42. 41, bringing in actions which we could generically call as prevent those possibilities, or if conflict has happened, if peace and security hasn't been maintained, to try to resume it, to take it back to it. But once those actions have even failed, then Security Council can order a collective action according to Article 42, in which there are three areas: actions by air, sea, or land forces, which could include demonstrations, which could include blockades, or any other operations. Any other operations would mean taking all actions necessary, which could include use of force collectively. Is this all? So UN is actually saying either United Nations Security Council can order a collective security to deal with a situation of this kind, or there's another area of self-defense that can be used to deal with issues in which states feel threatened or have actually been attacked. How to deal with that? That brings you to article, and the other article that I wanted to mention to you, Article 51 of. What does it say? It basically recognizes of individual or collective self-defense. Individual and collective actually creates some kind of ambiguity, and we will deal with that in some ways. In what sense individual or collective self-defense? If an inherent armed attack occurs against a member of the UN, So states and also that are members of UN, although there are some provisions for non-members as well. And it is only for till the time the Security Council has taken necessary measures to maintain international peace and security. And it also allows that the right of self-defense can be exercised by those members that have been attacked in whatever way, and whatever they do will also be reported to the Security Council, and will not in any case affect the authority or responsibility of the Security Council to carry out any of those actions. So self-defense is one area, and the collective security ordered by the UN are two areas in which use of force can happen legally in this context. So these are those areas which allow this, and there are several situations in which you tend to know or to see how the world has dealt with those cases. I think I can quickly pick a couple of historical examples that tend to determine or identify some of these areas. You think of the notions of self-defense, of how states have actually applied them in whatever way. So there's a typically a case called the Caroline case which is a case law, which talks about this notion of anticipatory or preemptory self-defense. Now you notice that while Article 51 says what it says, and we've just kind of scanned through it, there's a bit of a gap in whether you could exercise the right of self-defense, the inherent right of self-defense, before a physical attack has happened onto your state. So that notion of anticipatory. There are two schools of thought on this. One is the permissive school or the restrictive school. The permissive school would say that if the law is silent, you can take it as an interpretation that it doesn't stop you from it. But the restrictive school says whatever is the language that is mentioned in the law should be followed. So there are two views about whether preemptory self-defense or anticipatory self-defense can happen or not. Think of for example, the Israeli case and the attack on the Iraqi reactors. It exercised that notion. In 2003, United States went to Iraq in that context of taking actions against Iraq on those notions. In both cases, it was widely condemned that they were not justifiable. The way these states justified them, the argument and counter-argument is a long story, but basically the anticipatory self-defense went into a notion that that can be actually understood through the Caroline case, which was a ship. This is 1837, I think. And an interesting case of various states getting involved. An American ship called Caroline, used by Canadian rebels to hurt the interests of the British. So British went over and put it on fire and sent it down the Niagara Falls. And then the Americans were angry and they reacted to them, and they said, you must show the necessity of taking action at that time. And there was to and fro of these diplomatic dialogues. But Caroline case actually tends to say, if this kind of thing was happening, how would it actually go around happy? So the notion of self-defense comes out from there. Then there's another very interesting historical case of the United States versus Nicaragua, in which the US actually used the notion of collective self-defense. Nicaragua went to the International Court of Justice and said, they have mined our ports and they have hurt our interests, etc., etc. While the United States actually said that it was in support of El Salvador, which is a friendly country. The ICJ actually favored the notion taken by the stance taken by Nicaragua, and decided against the United States positions. So then sometimes if the UN Charter has some silence and the exact language, or the law has something silent, the case law is also seen as source of law. So the United States versus Nicaragua case now sets the precedent of how such ideas are to be dealt with. For example, in this particular case, the ICJ decided that in case you want to use the notion of collective self-defense, you need to have a request from the state that is affected. El Salvador was the affected state. That was the notion used. But although the United States quickly acquired an agreement, but the court rejected it and said when these actions were taken, this does not happen. And there are some other aspects also which actually set a precedent in that case. Now, so what is it telling us? It is telling us that if the law, the interpretation of the law has gaps, or if there are positions that have been taken by the court, then some more precedents come in, and then you can actually use them in the futuristic sense. So these are those ideas that that take you into this direction of how to deal with this. Now, one could go on talking about several things, but I'm cautious of this the timeline that I've been given. So let me just mention a couple of other aspects that, and then perhaps leave some to the questions. The issue of Gulf War is another area where how the resort to use of force happened, and some of those sometimes come to an idea where you decide whether the law allows this or it needs to be interpreted. Several of those areas, but those ideas start to come in. I want to mention a few things about the notion of jus in bello. If the conflict happens, use of force is actually happening. How does how to deal with that? So in the jus in bello, they are in the context of international humanitarian law. There are a series of Geneva Conventions, and the ones which are relevant to this are Geneva Conventions, 4 of them of 1949, which deal with the issues of how to deal with the wounded and the sick, of the forces which are in support of the land forces. Then the second one is about wounded and sick and the shipwrecked, which are at the sea. The third is about the treatment of the POWs, and the fourth is about protection of civilians in times of war. All of these areas come in and give you a sense of how to deal with this. These 4 Geneva Conventions are very telling. There's a lot of elaborate information in there, and then they were supported by some additional protocols. The ones which are directly relevant are Protocol 1 and 2 of 1977. What do they say? Protocol 1 to these Geneva Conventions is about international armed conflicts. And Protocol 2 is about non-international armed conflict and how to deal with some of those ideas. The sense that perhaps it would be of interest is something that comes out of Protocol 1 of the Geneva, additional Protocol 1 of the Geneva Conventions, 1977, which actually talks about the protection of the victims of international armed conflicts. It defines, the notion of people or peoples as it is put in this context. And it talks of 3 categories that could be fighting against the colonial domination or alien occupation or against racist regimes. And the protocol actually clarifies that this will be seen as being part of the international armed conflict, which basically is telling you that there's a recognition that people could actually pick up an armed struggle against these 3 notions. Now, we do know that colonial domination is kind of a thing of the past now. The racist regimes have been dealt with, although historically all of these things are extremely important. But the notion of alien occupation, you can think about how it applies in Kashmir. You can think about how whether the Palestinian case can be seen in this context. So these are these protocols that determine and help to identify some of those areas. Now, this protocol would add some clarifications to these Geneva Conventions, add some provisions, various ideas, we can talk about them. I want to bring in one or two notions before I end, which also should be of some interest. One notion is that if the law is silent in any ways, sometimes the sources of law will also is benefited through how to look at the state practice, a consistent state practice of how they dealt with those things. And that in a general sense is known as the customary international law. Customary international law may not be written down. There is, although there has been an attempt to do so, the Vienna Convention on the Law of Treaties in 1969 was an attempt to codify the customary law, the notion of state practice that came around. And these notions are also relevant because there are some aspects in which there's the notion of humanitarian intervention that states want to think. Now, states are sovereign, but if there's a notion in any part of the world where there are problems, and you can think of those, although case of Rwanda is also managed by the Genocide Convention. But when these things happen, UN Security Council has a responsibility to deal with this issue or to look at this issue so as to, in the context of national peace and security. So humanitarian intervention is one area, and one notion which is fairly well known in this context is called the R2P, the responsibility to protect. That basically starts to look at these issues within states where, and especially those areas where international armed conflict is happening, that has those salients. If there are situations in which states are seen as unwilling or unable to handle the situations within their own areas. But it's a very tricky area because intervention could also need to be seen as justifiable and not for political reasons. So these are some aspects which also bring out the notion of the areas of adequacy or inadequacy of it, or how to create the issues of balance. So I would want to kind of stop my rambling by drawing your attention to two broad areas in a contemporary sense of looking at this today. Is lawfare a thing which is kind of irrelevant today? I would argue no, it is not. However, there's a significantly low salience of lawfare today in the world. A lot of that is by using the gaps or the inadequacies of law to not only for the sake of interpretation, but to limit the actions of the international community in several ways. This is a somber, punchline to this whole situation. Does this mean there's no future of this, or it cannot get better? It can, and especially in the world of today, it is significantly important to understand these aspects of law so as to get into those areas, especially in view of the challenges that are emerging around the world, in the sense of technologies, for example, the way the world is evolving and the way it is heading. There are newer challenges that are coming around, and new questions are being raised or are likely to be raised. So let me stop here. I think I'm getting to 30 seconds short of those 40 minutes that I was given, and then perhaps wait for some questions. Thank you very much.
Thank you very much for giving this comprehensive overview of the linkage between the two the two important phenomena. I think you made a mention of lawfare at the fag end of your talk, and I think that's very important. And for countries like Pakistan, whose foreign policy challenges have got a lot to do with international law, they cannot ignore lawfare, and if they ignore, they could only do that at their own peril. So this sets the stage for a very good and interactive Q&A. I would request of everybody, those who want to ask their questions, to raise their hands, or if connectivity issues are too difficult to navigate, type your questions in the chat box. Please keep your questions short, avoid making comments. This I'm saying in the interest of time. So please raise your hands if anybody has a question. Okay, Imran, can you open your mic and ask your question? Please, one question would do.
Thank you very much, Ali. It's good to see Banuri Sahab again. I'm Imran Abbas, Assistant Professor, Department of Politics and International Relations, University of Sargodha. With an apology to Ali again, that I'm going to make a comment and then going to establish my question. So, sir, the comment is that, well, they say basically the law does not exist without the backing of the force. It's merely a positive morality. So given that, so we can actually make this whole topic a new name, that the use of force or necessity or legitimacy of use of force against the use of force that is probably illegal. So do you see that it is plausible to actually reach out to the goals of bringing in the law within the domain of the warfare and the use of force without having a use of force and the very intention of the major powers involved? Thank you, sir.
Thank you, Imran.
Thank you, Imran, for interesting question. Let me see if I can deal with it the way you expect me to. If I've understood you correctly, this, the thing that you perhaps want to get at is rather idealistic. The world does not really work in a very ideal manner. But I might be taking a chance and digressing from the direct notion of law, but there's always this blend of law and politics that tends to, or the state of international relations that tends to deal with those issues. But here's a thought. The notion of international law, and let me also contextualize this in another way. If you have, let's say, theoretically, you have a law that deals with all, theoretically speaking, all foreseeable situations precisely. And it has a cut and dried dealing with, this is a situation, this is a contingency, this is how it works. If it was even possible, then you would actually be straitjacketing into an action which is precisely the only thing that you could do. So law, why I'm making this point, the law tends to keep the notion a bit broader so that there's this, which leads to this notion of the interpretation of law. To pick this example, you say, this is one room, here are these 40 people, we are making a law which is applicable to these 40 people. If you change the room, if you bring in a 41st person, etc., it will tend to, it will require an amendment in the law. So what you need is to actually deal with any of these things to determine illegalities. But if the interpretation allows a situation where there's a gap in understanding whether this particular action is legal or not, there will be arguments and counter arguments. Secondly, international law as opposed to the state law is a very different animal. You need states to agree to a certain law when you make those, draft them, etc. And when you do, then they are to actually every state drafts or negotiates, keeping its own interest, national interest in mind. And so there are some inadequacies that come in. As long as the principle is correct and it is maintained, then you can interpret the law in a sense and determine what aspects are legal. So I think necessity will also determine that some of those aspects are legal. So let me end this answer by bringing out this notion that's called jus cogens. Jus cogens basically says there are few things that are beyond law, that you, even if you were to theoretically make a law against it, you cannot. For example, genocide. You cannot make a state law that actually authorizes and says, oh, some of those people are uncivilized, and those notions that people used to have, the jungles of Amazon and so on and so forth. And so you could actually, and they're cannibals, so we should kill them. You cannot do that. So the notion of jus cogens says there are few principles that have to be adhered to. This is where you play in the sense of necessity and the legality. Imran, that's the best I can tell you. Thank you.
Thank you very much for the question, Imran, and for the answer, Sir Banuri. So we have Sikandar Azam next. Sikandar, can you open your mic, introduce yourself, and ask your question?
Assalamu alaikum. Good afternoon. My name is Sikandar Azam Khan. I am a research fellow at Baluchistan Think Tank Network based in Quetta. Sir, my question is pertaining to the international law, that the international law has evolved through times, keeping in view the traditional aspects of the security. Conversely, there exist non-traditional threats in the domain of cybersecurity, climate change, and humanitarian crisis. Where does international law stands in those areas? Thank you.
Thank you, Sikandar. A straightforward, simple question, which is really loaded because this is the need of time. This is a need of time in the sense of how to deal with issues which are, and I think in my concluding remarks, I also alluded to this notion of the new challenges that are coming in, and this is one of them. What you do is, when you think of a threat like cyber, you also build from what exists in the law, right? So let me pick an example on this. There's something called, in the context of cyber, and if you're looking at this subject, you would probably know this, the Talents Manual, which actually tries to deal with this issue. And the Talents Manual also defines what can be seen as a possible use of force in this context. So there are two things. If there are injuries to humans, or if there are threats, or there some kind of structures are being destroyed or damaged. So that will tantamount to use of force. So what we want to relate with is, in the context of international law, if a structure has been damaged. I mean, think of, for example, the Stuxnet threat. Stuxnet was a cyber threat, right? We understand that it happened. It tried, but it also damaged some of those refugees that Iran had, right? That would, in my understanding, mean or imply a use of force. And hence the international law is applicable. So that's the simplest example I can think of. And several of these notions are still subject to interpretation also. So there will be arguments, there will be counter-arguments. But that aside, what exists, always look at this, what exists in the law at this point. So we can generally talk about inadequacies, but lots of time there are references available. It's a matter of interpreting them correctly. Sikandar Azam, I hope you can conquer the world that way. But going by your name, that is.
Thank you. Thank you. I think this was a very sharp and succinct answer at the same time. Arsalan Mehdi, please open your mic and introduce yourself. And please ask your question.
Hello, sir. My name is Arsalan Mehdi. I'm a graduate of I'm a graduate of SPIR Khaizam University, Islamabad. Sir, my question is related to Article 51. Sir, I wanted to ask that does perception or misperception in international politics invoke Article 51? Sir, if I may add something, since along with other reasons, the perceived threat of NATO expansion triggered Russia intervention into Ukraine. Thank you, sir.
All right. The issue of perception, very, very, very interesting area. There are several journal articles, research articles written on Article 51, how to interpret it. And it does have some areas which actually need significant interpretation. Several have been interpreted in various ways. Article 51, one area is very clear, that's a notion of self-defense, an inherent right. It identifies that. But then it also talks of an attack, armed attack that has happened. So, the issues which are seen as gray are like, for example, does it include the possibilities which are not written there in this context? I'm just pulling out the exact text of this. The right of individual or collective self-defense exists, but if an armed attack occurs, Now, if there is a perception of this, usually if this was the only language, then if the issue of perception would not hold true. But since it does not preclude, the language in the Article 51 does not preclude the preemptory nature of or anticipatory self-defense, the issue of perception becomes relevant and important. Now, you rightly brought out the issue of Ukraine because it's right in your face in the sense that it's happening. There are several interpretations of whatever ideas that have come out. Let me just pick on one or two thoughts. What has happened in, the case has gone to International Court of Justice. What has happened there? There's a dissenting view. Of course, the dissenting view is from two judges, which are from Russia and China. But should I say, of course, the judges in the International Court of Justice and some of those are permanent positions from several states, and while the others who could be put in some kind of, not necessarily from a particular country. But those judges are to give a verdict on, or they give even a dissenting view based on the information which is legally, the legal side of the information. So there are some gaps that exist. For example, this notion that I mentioned to you about United States versus Nicaragua, where the American perspective was that it was aiding a friendly country, El Salvador, in doing whatever it did. Now, in the case of Ukraine, we know the political reasons, and since you are a student of politics and national relations, you would know them better, that we know the political reasons of the presence of NATO and on the borders of Russian Federation, which could actually directly impact those interests or the perceptions, as you say. But the notion of the republics that Russia mentioned, the Donbass, and I'm very bad at pronouncing the correct names, that it is based on that request. In the Nicaragua case, United States did not have a available request of El Salvador, which it acquired later, and hence this case was rejected. Now, case law is available to the Russians because that case happened a long time back, and they seem to have a request from these republics to come into their self-defense. So their arguments, they are seen as weak. In a broad context, when you look at international law, you would say this attack on Ukraine, and some will argue that earlier the Crimea one as well, is a violation of Article 2.4 of the UN Charter. But the counter arguments still exist, and as they say, the jury is still out on that. That seems to suggest that if you only use the notion of perception, which was your question, then they will be, the burden of proof is on that state which brings out that perception. But that is a real gray in Article 51 of preemption. And preemption has various areas in which you find that what if there's, there are areas that you need to think of. How if you anticipate, you have that perception, if it is going to happen, how soon is it going to happen? If it is, if this is your perception, that is it based on certain facts? So all of those assessments will happen. At the moment, this is a kind of a debate on weak arguments. Thank you.
Thank you for this question and for this very comprehensive answer. And I think, as you said, the jury is still out on many things that we discussed. So a lot of work should and must be done in these areas. So we have Adila Ahmed next. Adila, please open your mic, introduce yourself and ask your question.
Okay, thank you. My name is Adila Ahmed and I'm a PhD scholar at University of Lahore. So, sir, kindly my question is that what is your take on R2P applicability to occupied Kashmir? And second one is, sir, again, what is your take regarding after demographic changes in Kashmir? How you think UN resolutions relevant and how? So kindly please, sir, your take on it. Thank you.
Thank you. Now this is a very, very overarching question. I'll try to be as brief as I possibly can. The notion of R2P, the responsibility to protect, that sense comes in of there's something happening in there. It requires humanitarian intervention. It requires this because the state that is dealing with this is either unwilling or unable to handle it. That's the notion that you are thinking of. Now, let me make you connect with this issue of Kashmir in a broader context. I did in my presentation, I mentioned a few aspects about this. So let me link it with that. The notion of Kashmir, the International Illegally Occupied Jammu and Kashmir case, IIOJK, is, in my understanding, a very clear case of international armed conflict, on which is the applicability of Protocol 1, 1977 of the Geneva Conventions of 1949. International armed conflict, Protocol 1. All right. Now, it is, there's no rocket science to say it is, the case is, there are UN resolutions very clearly that identify this as a disputed area. And it has that status. The UN may be inactive on several of those actions thereafter for so many years, but that is the position that it has, and it remains that way. What is happening, and it is kind of in some ways successfully misled by India, is to portray this in broader context of that it's a domestic issue. It is not. And it is not even what is happening in Kashmir, which is controlled by India, is not even a case of the non-international armed conflict. It is not. It is an international armed conflict. Okay, so keep this in background. So the issue of demographic changes, which actually comes out from how India is trying to change its constitution. But these are those aspects that got changed anyway, gets addressed. But let me just take the broader question that you have, which is R2P applicable? In my view, it is applicable. Why is the international community not taking this action? R2P is not part of the UN Charter. We all understand that. But it is a notion that comes out of this. How do you say that it is relevant to the case of Kashmir? Look at it this way. Protocol 1 of the Geneva Convention that I mentioned, as I said, it actually says that there are 3 areas in which states can pick an armed struggle against 3 things. And one of them is alien occupation. This is a case of alien occupation. The military, even in Indian military, even if it is not, its sheer presence is also objectionable. Then whatever atrocities that are being dealt with, given in that situation, what India is doing is to use some of those gaps. For example, you see a lot of literature. You also see the concern of the Human Rights Commission, Office of the High Commissioner of Human Rights reports on the issue of pellet guns, which has blinded several people or maimed them. The gaps that are being used are, for example, the pellet guns. How are they categorized? There is a bit of an ambiguity of are they seen as non-lethal weapons or not, largely categorized as that. But non-lethal weapons, if it damages or destroys an eye or hits someone who gets maimed, then it is this aspect of lethality. So there's a gap there, and which is being used that way, but it is also this issue of proportionality of how to deal with any of those things. You look at those Geneva Conventions; they are all, they bring out those notions which India needs to adhere to that thing. So it is applicable. How do you then find that why it is not significantly already in the UN? And let's keep the politics aside of how the world wants to deal with India and so on and so forth. Here's a gap. And I have referred to Protocol 1 of 1977 several times. There are states which are very peculiarly absent, who have not even signed it. India and Israel. And you link it with what would have led them not signing these protocols, because the additional protocols need to be ratified separately from the convention, right? So they're not signing them because of Palestine or because of Kashmir. That's the political side that you would understand that have led to it. Then does that mean that India cannot even be questioned on this aspect? No, it can. The notion of customary law, the notion of state practice actually challenges that. So there are some areas in which these issues can need to be dealt with in various ways. One more point on that. The International Court of Justice, the International Criminal Court, the ICC, deals with those individuals which are involved in crimes against humanity or war crimes. And these are war crimes because it's an international armed conflict. how does, who would draw the attention of the ICC onto this? There is a provision within the ICC, the International Criminal Court. The Prosecutor General of the ICC can take note of a situation which is evolving. This basically means that there should be a lot of information which is factual about these atrocities that should be going to the Prosecutor General of the ICC. So there are several ways of how to bring this up and deal with it within what international law allows. So look at it this way. Thank you.
Thank you very much. This was a very important question, and that's why the answer was also very significant for future research and for future discourse generation, because Kashmir is boiling and there are less answers that we have to deal with the simmering issue in Kashmir. I will take a couple of questions from the chat box. So Alina Afzal has asked, she's a BSIR student at the AI University Islamabad. She has asked 2 questions. What do you think are the greatest challenges of international criminal justice in the context of changes brought about by modern technologies? Second, can international law limit the territorial sovereignty of a state, and on what conditions?
Please repeat the second one.
Can international law limit the territorial sovereignty of a state, and on what conditions? Okay.
Okay, international criminal justice. I think I missed the last bit. International, you're a bit too fast.
Can I repeat the second question once again?
Yes, please do.
Can international law...
Repeat both, please. The first one as well.
What do you think are the greatest challenges of international criminal justice in the context of changes brought about by modern technologies? Yes. Okay. Next, can international law limit the territorial sovereignty of a state, and on what conditions?
Okay. Oh, okay. Both very, very good questions. Let's look at the first in the order that they came. The challenges to international criminal justice in the sense of technology. There are challenges, but there are also advantages. Where technology also provides more evidence to several of these criminal justice areas. However, those, sometimes there are limitations of can that evidence be considered permissible. So those are the kind of challenges that perhaps can actually deal with those. But there are other areas. There are other areas which are, for example, the issue of deepfake. If you could, deepfake could actually be so convincing to consider whether a person is taking a particular position, in the sense of threats, and then refuting it. But then there are also these there are ways to determine. Although it's not, the immediate reactions are more sensational, but there are ways to determine whether this can be considered or not. Some of those challenges are still evolving because technologies are still, are actually changing to a level where these things happen. Then there are some advances of technology which are going to raise further challenges. Because international criminal justice is a very, very wide term. So let me pick on one idea of the notion of Bitcoin, these currencies which actually can, lead to robbing individuals, companies, or states without their, even suspecting it. Those technologies can actually do it very, very effectively. Those areas are still evolving. But criminal justice by itself is something that I haven't really focused on. So I should admit that I need to perhaps follow this a little more myself to understand this. On this the issue of the international law and the sense of territorial sovereignty. Territorial sovereignty is a very clear position in Article 4.2. However, there are other sovereignties which are not, because that's the physical side of it. In the sense of when you go into this, and sometimes the definitional aspects is cyberspace part of the territory of that state? How much high can you go on top of the top and cross over a state, like the satellites cross over various parts of the world? Can it also be a limitation? So some of those areas are unanswered. But if you look at the physical side of the territorial sovereignties, that notion remains precisely defined the same way. The other challenges which are evolving around it are evolving.
Thank you. These were important. This was an important set of questions, and I think the answers will help Alina articulate her thoughts going forward. I'll take another question. Shayan Hassan, kindly open your mic, introduce yourself, and ask your question.
Yes, hello. Hello, can you hear me?
You go ahead, Shayan.
Yes, thank you, Ali, and thank you to Sir Banuri for the very comprehensive lecture. Sir, you mentioned the UN Charter, and that I believe it was Article 51, that there's a bit of a gap in terms of what justifies the use of force. So could you contextualize this debate in terms of AI and robotics, and sort of what challenges could arise in this area from these new technologies? And so could you give an example from history of how when a new technology was introduced in the military domain, how international law was formed around that? Thank you.
All right, that's let me see if I can handle this part of me. Yes, in the sense of artificial intelligence and robotics is this sense of perhaps the same notion that I mentioned from the Talon's Manual. I believe you would have read it. If you haven't, this is an area that you need to kind of familiarize yourself more on. I think the notion still exists so far on physical injury or physical damage. Beyond that, at the moment, is something that hasn't gone into a lot of detail. So that's the notion that olden times, you would have soldiers going to war, going into conflicts, and doing this physical hurt. Now you don't really need to. You could be sitting in your lounge and fighting that war. And increasingly, this is going to change further. So the notion of war is changing. The notion of the objectives of war are also changing. And that is why the broader context of you don't really need to create physical hurt. But our objectives still remain, because I'm talking about the use of force, the definition of use of force still remains in a physical sense. That now needs to be seen as a limitation. While there have been some attempts to start looking at those aspects, for example, there was a series of group of governmental experts meeting in the UN to think of the ICT in the context of national security to understand this area, or to create those limitations, or to define critical infrastructures which can actually cause that harm. are now increasingly considered to be part of the use of force area. But when these notions were evolving, and that's the other part of your question, in the sense, I don't think that this was even conceived that the technologies could actually take you to that kind of a level where you will be thinking of beyond physical hurt. So I think there are gaps, and some of those areas haven't been looked into. Some of those areas would have been already under consideration of the international law experts, but they aren't. And my understanding of this is that while these technologies are evolving, there's a lot of interest to actually get into the bandwagon, to understand this, to acquire these technologies, because as I always argue, the emerging technologies, several of them, do not really require a very highly evolved industrial base. So several states which may not be major powers can also acquire them. So there's this kind of a race to acquire these technologies, and only when significant number of states, or especially those who are considered to be the major states, have significant control of those technologies, then there will be more attempts to actually bring in international law and try to limit it to the states that already have. That process, even if it exists, is negligible at best, in my understanding. Let me stop here.
Thank you. I have a couple of questions that Zubaida has posed in the chat box. So the first question is, she asks, can we say that international law is still effective, taking the case of Ukraine-Russia war, since nothing has been successful to stop the conflict? And number two, it is evident from studying the history of the world that many times international law has been manipulated by some countries, and they have gotten away with it too. What mechanism is in place to stop such manipulation for personal or a state's interest in this case? So these are interrelated questions, one way or the other.
Sure. Zubaida, there are three questions. So first one is pretty obvious, I think, that looking at the Ukrainian war, when you say, can we say that international law is still effective? International law is, let's just rephrase it and say international law is still applicable. However, it's clearly inadequate in this applicability, but inadequate in the sense that while the discussions have happened in the international arena like the ICJ, it hasn't gotten anywhere. And it hasn't gotten anywhere because when this notion of the UN Charter was evolved, that it did not preclude the possibility of having veto powers. And in fact, even in the contemporary sense, there are states that are trying to get a status of veto power, which countries like Pakistan are against. So those are those things where more divide between haves and have-nots will get created, and that's the argument that you will hear from countries like ours. But and it is not effective for these kind of limitations that they have. What these several times, and now I'm actually walking away a bit from the main arguments. Several times the solutions are more political than legal. And that how does the United Nations become relevant? It provides the forum for all these states to be there to actually talk about it and resolve those differences. So the mechanism exists, but it hasn't been used effectively. On the second question, it's an interesting one, and I actually mentioned this, that this is the kind of reference that they used, and you can think of United States, Nicaragua again, to say that this is the kind of support or help that was sought from Russia, and that is the argument that it can use. What would have been the proper alternative to prevent the war? The proper alternative would have been a political assessment of, politically the notion existed that Russian Federation would feel threatened if NATO is at its doorsteps. For years, the NATO and Warsaw Pact have dealt with Cold Wars. Now, this was a situation which you can see as proxy to actually signal to the rest of the world that there's a red line which should not be crossed. So there was a possibility, and I think there still is, to actually get around the table, preferably in the UN, to actually resolve this. But it's, would it happen? It can be your guess or mine, but very, very remote possibility. Okay, I'm trying to look at your third question to refresh myself. Manipulation of international law. Now, I think the word manipulation might be a bit of a stretch, Zubaida. It's the interpretation of international law, and interpretation has to be supported by the legal understanding of international law. And then it needs to be seen that way. If so I would think that the word manipulation in this is rather delicate. What should be done if to actually handle such interpretations? You need two things. You need an international system where this forum, a forum where these things could be discussed. Personal interests are not an issue here because these are state-to-state interests. Even if you're thinking of Ukraine and you're thinking of Putin as a person, you need to see that here's the person who actually is heading that country, and that then that becomes the state interest of the determination of the policy, the national policy that a decision maker is taking. So a state interest needs some kind of negotiated settlement. And that is why a negotiated settlement of this area to determine how far, just relate this with in the times of Cold War, how both the former Soviet Union and United States actually were able to talk to each other, although with great difficulty, to balance out how many launchers they can have, what forces to keep in Europe, how many the conventional forces in Europe, and so on. Those ideas, those were negotiated positions. Those kind of negotiations still the path to solving this problem. That's my view.
Thank you. There's another question in the chat box by Rahat Arshad, a student of the A University. We can see that the international community has somewhat moved from direct use of force to economic sanctions and non-military measures when dealing with conflicts, as can be seen in the Russia-Ukraine conflict. How effective are such measures in achieving political gains? It's a generic question, but obviously related to international.
Yeah, I'll try to be a bit crisp on this. Please understand that these provisions have existed in international law, even in the UN Charter that I mentioned. There's a whole chapter that talks about use all peaceful means to resolve conflicts. Chapter 6, right? If those things don't work, then you come to chapter 7, which involves the use of force, and to look at this. And even in chapter 7, Article 41 of the UN Charter, which is part of Chapter 7, dealing with the threats of peace or the breaches in peace or acts of aggression. Even in that, it talks about the sanctions, the possibility of sanctions as a means before you think of resorting to physical force. So coercive means, including sanctions, are part of the pattern anyway. And that those things have existed. Now, it's not a new phenomenon that the world has moved in that direction. It's just that, relatively speaking, there are lesser possibilities of physical wars now in the contemporary world. That does not mean there will be no physical conflicts at all. They still happen, but they are likely to remain contained in this sense. But the issue of sanctions or other coercive means still exist. Even those have limitations, as you would see in the case of Ukraine. While those sanctions led by, perhaps pushed by United States as in the world community, but also supported by several Europeans, are happening. But also keep in view that there are lots of economic interests that, for example, Europe has with Russian Federation, about 30% of oil, and so on and so forth. So there will always be considerations of national interests, balancing those while you impose a lot of sanctions. So that's the kind of environment that how the world exists and fights.
Okay, thank you. So there's another question in the chat box by Fazlillahi Bilal. He is a PhD scholar at my university, the University of Lahore. He says, what do you think? Does international law on the use of force have any inherent structural legal flaw, or does it fail to prevent the United States from using force in the name of humanitarian interventions?
Well, I think there are limitations, but there are no flaws per se. That's what I will argue. No inherent flaws in that sense. There are limitations. How do those limitations come in? Two things that you need to consider. One is that while the conflicts happen, even if you're thinking of all possible ways of solving international disputes, you need some mechanism. You need some arbitration, which means you accept an arbitrator. You need some kind of negotiations in which both sides sit through, and lots of times the negotiations can deadlock. So there are various ways. If you look at those possibilities, then perhaps one could argue that you would want to have someone, a neutral party, who could actually listen to both arguments and provide some solutions. United Nations is one such forum, Security Council. The other all aspects of various things that you could do, negotiations and several of those ideas on which you sit around the table, are all those possibilities that you have. Lots of times when in an argument, if there are two states that are party to that argument, it is kind of difficult for them to arrive at a compromise. Although negotiations do happen and at times are successful, they will simply only be successful when both are looking at some interest that they are achieving. So you need a kind of a third party in some sense, which is perceived by both sides as neutral. So that's the need. For that, the mechanism does it have, well, what the so-called flaw? Look at this notion of the veto, where there are some haves and some have-nots, in which a state could veto an otherwise possible solution. This you could term as flaw, but I would rather say that this is a limitation because it has some, kind of a possibility of balance also. Otherwise, there would be a deadlock on those, and deadlocks for a significant time would tend to lead towards a physical conflict. So that's the balance, that's a compromise that you need to look at. Thank you.
Thank you. I think this is where international law interacts with the international relations and the structure of global politics. Because obviously, we follow, if we were to follow a structural realist approach, we could definitely argue that power, the hierarchy of power, has a direct bearing on how international law is used, abused, and reused, much to the liking of the powers that be. So this is how the cookie crumbles, and the world is not a fair one, and it does not offer fair deals. So we have a question by Usman. So Usman, could you open your mic, introduce yourself, and ask your question?
Thank you so much, sir, for this insightful presentation. I have a simple question. I am Mohammad Usman Kareem from National Defense University. I have a simple question. Security assurances were given to Ukraine by the US and even by Russia in the 1990s. Similar kind of assurances are given to Ukraine, and there is Taiwan relations. Similar kind of assurances are given to Taiwan, and there is Taiwan's Relation Act of US Congress. So what is the credibility and status of these sort of assurances or acts in the international law? Thank you.
Look, this is an interesting angle that you bring out. Let's look at the realism or shall we say, the realpolitik of it. The credibility of this will be determined of how much a state wants to indulge into taking the next step, shall we say. Now, in the case of Ukraine, there's a kind of a united front of, shall we say, the Western world. The Europeans, the Americans, and all are supportive of, let's support them. What have they done? They provided support, they provided some technologies and weapons to Ukraine, but they've remained short of any physical intervention. If you wanted to go into a physical intervention, what are the things that you have? You need self-defense, which can be done by Ukraine, or Ukraine can actually request, which it did, to several states for physical force. But what would that mean? That would mean any state getting involved or sending its military is getting involved into a conflict which will then expand to beyond a bilateral level, which is where states have stopped short and of actually doing this. The other possibility is asking the Security Council to decide on collective action. But can you actually sit in the Security Council and take that decision? Because that is where Russian Federation, which is a veto power, will weigh in. So that's the limitation that you have in that system. And you also see this credibility question of, you need to see this in the context of realpolitik. Sometimes people turn around and say, what if Ukraine still had nuclear weapons? Remember, Ukraine did have that capability, the Ukraine, Kazakhstan, Belarus, but they were not really the possessors who had evolved the nuclear weapons. So that's a different case. But if there was a deterrent, then perhaps there would have been more contained conflicts. The conflict would have still happened, in my view. Thank
you. I would now like to ask Jamal Nasir to open his mic, introduce himself, and ask his question.
I am Jamal Abdul Nasir, and I am a student of strategic studies. Sir, my question pertains to cyberspace. Cyber weapons are mostly launched, military-graded cyber weapons like Stuxnet are launched by country A if against country B. But we see that cyber weapons radius of effects is more than the radius of effects of conventional weapon. So if country A launches a cyber weapon against country B and its fallouts are felt in a country C, which are more harmful than in country B, can country C retaliate against country A under IHL? Please, sir.
Okay, very interesting question. Thank you for that. My short answer is this is already in the gray, and you're stretching this gray by this question more. Let me elaborate. First of all, we know about Stuxnet. For example, you took the example of Stuxnet. As is widely considered, United States and Israel separately or together, or either of them, was responsible. That is the widely held literature that exists about this. Now, you can think of a country C and say, what if the fallout is going to be on very, very bad on that? Can it take action? Look at the action that the country A and B have taken against each other. One aggression has happened. The defending state hasn't, Iran in this case, hasn't gone to a physical conflict level. It has used diplomatic means to react to it. While your question is absolutely theoretical in the sense of whether a third country can do something about it, the third country, according to the UN Charter, can raise the issue in the UN by saying, this is the impact that is coming onto me. Even in the case of sanctions authorized by UN on any country, if a third state is getting affected, for example, if there's a sanction that say this particular country will not be allowed any exports, for example, and the country next door says, my food security is ensured from this, and no, I'm going to get affected. It can go to the UN. It can actually raise this point that my security is threatened in this way, food security in this case. So those possibilities exist. But if you're looking at a physical attack like Stuxnet, and then think of a country C, it can raise it in the UN. It cannot, in my view, it will be quite a challenging thing for it to consider any physical action in this case. That's my argument. Thank you.
Thank you. Imran, I think, has raised his hand once again. Imran, please ask a question if you have.
Thank you, Ali. Sir, my question is that if law is always subject to interpretation, this opens the window of very subjective conclusions. So how you see the right of hot pursuit being applied by America during the war on terror and conducting drone strikes in Pakistan, and then it gives the obsession to India to use the notion of surgical strikes against the terror infrastructure. Now, how can they be, convincing it to the world audience, not even to say that the risking of escalation was there? Thank you.
Okay, very interesting. But I have a bit of a challenge to the word always in your initial part of your question, that law is not always subject to interpretation. Several times it is, if it is not very clear, if the situation is not very clear, or the situation has evolved which hasn't been foreseen earlier, or there's no case law available, or no direct reference to it in the existing law available. So yes, so lots of times interpretations become a relevant thing. The notion of hot pursuit has existed in various forms for a long time, right? It has its challenges as well. It has the chances that the nation carrying out this hot pursuit will also be taking. Lots of times, if the hot pursuit is on through using technologies, there are also rules of engagement that contain how much can this be done. Some of those areas exist, but the kind of notions that you mentioned that came from the United States was in the context of counterterrorism campaign post 9/11 that it evolved, and there was a very significant effort to go into this. So there is a law that it's a national law in the United States called the Patriot Act, which basically dealt with some of those areas which weren't really conceived earlier because of this new threat. And this notion of non-state actor, which because the UN Charter by itself deals only with states. And so non-state actor, the role of non-state actor, and in the context of, if you want to refer to the Charter as Article 51 of self-defense, came in the UN Security Council Resolution 1373, which dealt with the 1267, brought in this idea of the Counterterrorism Committee, but 1373 is something that actually recognized or referred to the right of self-defense. So, and this then became a reference to the non-state actor threat. So that sense came in, but involving the state, or if you're going to cross a border in another state, then it needs to, it needs involvement of that particular state, either action by them or with their permission, and so on and so forth. So these ideas of hot pursuit will always be seen having a significant risk, inclusive of the states that are ordering them. Now, but once something like this happens, if it needs to be challenged, if it is perceived to be an illegal act, it needs to be challenged, because if it is not, then it is becoming a precedent. However, the realpolitik also suggests, and Imran, you are an expert on that yourself, the realpolitik actually suggests that if some kind of precedent is seen usable, other states will do it. The typical case of, think of the Iraqi reactor where Israel carried out an attack in a preemptive sense, and also think of the United States going into Iraq. Pretext, of course, was the sense of, they have weapons of mass destruction and so on and so forth, which, later on, it's very clear that it ain't. However, the notion which was used for the United States to go into Iraq, the notion that was used was not the WMD. The notion that was used was violation of the ceasefire. So they are legal interpretation that will be used to a state's advantage. That will happen. You can see the Indian resort to notion of surgical strike in the same context, but you can also see that how poorly it failed when it tried to escalate. India tried to escalate in the aftermath of the Balakot. So they will always be challenges and limitations. Thank you.
Thank you very much. I think from the last answer of yours, one could also make a mention of how international law and its concepts could be used as pretext for getting into crises and also trying to manage crises. Because if you talk about Article 51 or other articles of self-defense under the very rubric, we can then devise mechanisms whereby international law could be seen as one of the elements that could ensure crisis management. Although this may sound very difficult as of now, because as you talked about hot pursuit operations, we also heard that the Pakistani Air Force undertook airstrikes inside of Afghanistan in April or May. Now, international law could be challenged by these cross-border terrorist attacks. Like, for instance, if we know for a fact that the TTP or other inimical forces operate out of Afghanistan and there is no other option but to carry out attacks on their safe havens, this would become a challenge for countries like Pakistan. Maybe you could give your thoughts on that and add to that your closing remarks, because we don't have any other questions for now.
Okay, thank you very much. A couple of thoughts that one can bring on this. This issue of the notion of where Taliban are in Afghanistan, etc., etc. One of the notions that, and you're thinking of the notion of law. Generally, the sense that you will have in the context of who's running, who is in control. So if the government is Taliban, then they are in control, and that's the notion that is being seen. In this case, the acceptability is still under question because, this did not happen through elections, but the sense of control came around. So this notion of use of force should also be, in the case of Afghanistan, should also be seen in this context. Now, but other than that, I would generally say that any physical use of force, through air means or other means, will these notions of hot pursuit and so on and so forth exist because they are examples of realpolitik, but the notion of making them as a legal method is when the only reason you can use this is in the sense of self-defense, if it is justifiable, and it is reported to the UN Security Council the way it is required under the international law. The only other way of using force in this context which is legally allowed in the charter, is collective security through Security Council. In addition to this, the notions of humanitarian intervention, the R2P, or those ideas existed, but they will always be done extremely selectively as they will be used. So they are some aspects, but they need to be carefully considered in evaluating them. The sheer use of force without legal justification is not something that can ever be accepted by any state. However, if it happens, it is a violation of that law. So that needs to be contextualized in this manner. So that's the sense that I would like to mention. But overall, 2 or 3 things, if I was to kind of look back and say, depending on these questions or the discussion, what are the thoughts that come around that you start to look at? 2 or 3 thoughts that perhaps you want to consider. You needed an international system and a concept of international law, because otherwise state laws, which were legitimate laws for all states, did not speak to each other. The laws did not speak to each other, which means there was no system of dealing with them. So you needed this. When you and the urgency of having some kind of international organization like the UN also came around because millions had died. Now there are some situations that have evolved, like Kashmir, for example, which is simmering for such a long time, and it has been referred as an open jail for so many years and all. All those issues have come around. The question is, would the international community sit back and only take significant action when more millions die? Or would it be prudent enough to actually start looking at those aspects. So these are the takeaways, and the major takeaway out of this is that the law and politics actually tends to blend and overlap, and it needs to be kind of considered that way. Then dispute resolution among states is a very difficult animal. It's and it needs special effort by each party to that conflict. These laws exist, but then this issue of interpretation. Please remember that international law is to be exercised in good faith. In good faith. That is the sense that is there. You do not stretch the language of the law just to prevent an action or to carry out an action. You do it in good faith, in the spirit. That is why laws require to be seen as what is the object and purpose of a law. And if that object and purpose can be met or not, will be the question. Last thing that I want to say is the newer challenges, and there have been several questions relating to that, are the issues of technologies. Now, this is a new gray, shall we say. It is evolving. There are more challenges, but there are also not a lot of effort to actually arrive at legal solutions as yet. But the scholars need to continuously evaluate and dispassionately decide on how they can be dealt and balanced in the context of the newer challenges that will come around. New technologies in particular are those that start to evolve, but also keep in view, it's been several years when someone said there will be a time when you will be able to see each other while you're hundreds of miles away. That was the advent of the television. It seemed unbelievable at that time. Today, the newer technologies are coming up with ideas where we think they are completely inconceivable. There are ways to look at how to balance them and how to set rules. There will still be violations. The states will tend to do it like individuals violate law, but then if the law exists, then it will try to balance those situations. International law also has this notion of the community trying to balance its respective national interests and adjusting them to each other. So those are those areas that need to be seen in this context. There are advantages of having these laws. They need to be strengthened, and there need to be an effort to do it, making them more robust and prudent. However, there will always be attempts to walk away from them, and the states need to recognize how to deal with them. And let's also look at one possible area. One state having an all overarching control is tantamount to what, let's say, a dictatorship is in a country. So that's not the solution that you have. When states are able to negotiate their positions and balance out, that's where you find solutions. So these are the things that you need to understand. Final point on technology is that while these technologies do bring in new challenges, and there are some challenges that are yet to be understood or brought out, there is relatively lesser possibility of many armed conflicts. That does not mean armed conflicts will not happen. That means the salience might be reducing. How we can help this situation as international community is to ensure that the salience of lawfare does not reduce. If the salience of physical warfare can reduce and the salience of lawfare is higher, then there will be a likelihood of more balance that will exist. The notion of conflict and cooperation will have to coexist. That's where I think I would like to stop. Thank you.
Thank you very much for summing it up so beautifully. And I think the last you said that it's conflict and cooperation have to go together. And I think international law provides that semblance of balance. And the more we adhere to the principles of international law, the more we are likely to have that balance which is necessary, especially at a time when conflict is coming back in the game, and it is coming back in the game pretty strongly. We have seen diplomacy take a back seat, and I think one of the things that can rescue diplomacy is the adherence to international law. And on the contrary, international law, if not adhered to, could lead to more conflicts and more violence. And that is something that a world which is ripe for economic connectivity, integration, and a geo-economics-led world order can ill afford. So I, once again, on behalf of TRAFASIA and FES, thank you for giving such an excellent talk. And I also must thank all the participants for their incisive and thought-provoking questions. I'll also like to say that the next session will start in an hour or so, and I would like you all to join then. Thank you very much.
Thank you.
Thank you, Sir Ali. And thank you, Sir Banuri, for giving us a very, for me, it was very thought-provoking seeing how international law and the depth of its applicability in any sort of situation, going from the past into the current conflicts that we see. So thank you so much, and to the participants for really keeping the discussion interesting and engaging. I think with that, I just have a few announcements. The next session is at 6 p.m. So everyone can join then. It's with Dr. Tariq Rauf on the future of arms control. It will be quite interesting because each of these, foundational concepts, they are facing new and evolving dimensions and challenges. So it will be a very interesting one, much like the one we had right now. And I think with that, we can close. Thank you, Sir Banuri, for joining us. I just have a 1-2 announcement for the participants, which I'll cover later. So all the participants, you can stay.